Welcome to another exciting episode of Unraveling Intellectual Property with Michael Stein. Today, I am pleased to have Axel Stellbrink back for part two of a series on uh, protecting your intellectual property rights in Europe. Uh, the first part of that is uh, learning about the process, and the second part is we're going to get more into the AI and the protectability of that. So, Axel, we already went into some about having to go into specific countries. Is there like a national, was there a change in system or an addition that you don't have to go into each country individually? You have a unified patent or
Yeah,
something?
absolutely. The UPC, the Unified Patent and Unified Patent Court, which has an upside according to the perception, particularly of the big industry, but also downside. Upside being you can then enforce your patent centrally with one proceedings throughout the EU, countries being a member to the system, which at the moment are 21 countries. Not all EU countries are members,
Okay.
but the majority. Spain, for example, is not a member to the EU system. I think they were upset about Spanish not being chosen as an official language, but I don't know.
All right.
And then you have to pay, so to speak, four fees equivalent to four countries under the former regime. And then you can expand this patent to all these 21 countries. And the downside now being also the patent can be invalidated centrally. So if you have one attack against your patent,
Yeah.
it can be revoked for all those countries. I mean, which is for you in the US clear, but here in Europe it has been different. And this is why Big Pharma, for example, is still picking the old system. They want to divert the risks also. I also have a bit of critique. I think that many patents are not properly drafted. So my recommendation is always to properly draft a patent application. Never believe with quick and dirty you get along. No, this will not pay off. And if you do this, then of course your patent will also be fit for the unified patent system, and you have more lines of retreat, etc. So you can better handle the risk.
Right, right. And then in the United States, we follow our application, we get the whole process, we get examination. It's a little bit different in Europe. Can you go into that whole requesting substantive examination or whatever the exact language is?
Yeah, we have a stepwise procedure. So you can do it in one request, but sometimes it's being done in a split request. You first ask for a search. You want to see, hey, what do the patent examiners find as prior art? And there's always new prior art. You know this, Michael. When we send cases from Europe to the US, in the US PTO, you find more prior art we didn't know before, and vice versa,
Right.
pretty much the
Yeah.
same. And then you can see, and there is usually a first statement, a qualified statement of the examiner, and then you can decide if you want to split to carry on with the substantive examination proceedings or not. Uh, yeah, it depends. I mean, big industry is usually doing it in a combined package, I would say. If people want to see more the result of the search, then they probably do it stepwise.
All right, understood. All right, let's get into the whole AI component. Everyone's doing it, I'll say these days. We're filing a lot more AI applications that impacts just about almost every area of technology. I'm sure the same with you. So, what's the situation over there? Protectable? What do we need in the application? What inventorship issues? I'll leave the floor to you. And if you have,
Okay, cool. Yeah, yeah. So first of all, thank you for asking, Michael. Very important. There is a difference regarding inventorship, by the way. So it is not so detrimental, I think, in the US not to designate an inventor. Here in Europe, it can be very detrimental, like the CRISPR-Cas cases have shown. They have omitted to list one inventor, and many of their patents have been revoked because in Europe, the applicant is then not considered to be entitled to file the application if not all the inventor's rights have been transferred. So this is a big difference and danger. So this is something we are also then asking our foreign associates: are all the inventors being Now, second question. So you have asked for the protection of software and AI is a big thing now, okay? And
Right.
most of these applications are being rejected for several reasons. It is the abstract subject matter objection. Like in the US, we call it a bit slightly different. We call it more technicality objection. So here again, my recommendation is always, of course, you can protect software and AI. Probably in Europe easier than in the US still. It has been in the US much easier than the pendulum swung to the other side, I would say, and now Europe is more liberal. But of course, you have to tell a complete technical story. Let me put it this way, meaning that you really have to disclose all the features of this AI. Not, hey, AI is applied and there is a feedback loop, I don't know,
Right. Yeah,
training.
we're using a large language model, and hocus pocus outspits a magic number.
Yeah, exactly. But here, this is no, this is deadly. You need to go to into the detail. And when I talk about storytelling, it's very important to also not only list all these features which are beneficial to the invention, but also the benefits. This is very important in the boards of appeal. I have a very good friend there, and he is telling me that more and more they want to see the benefit or the advantage of a certain feature to be discussed in the specification. For example, one of the biggest arguments there obviously is to defend some AI or software-based invention is we are saving computing power. If you come out of the blue with a statement, they usually don't trust that this is correct. But if you have acknowledged this already in the original specification, they believe, okay, this is obviously part of the teaching they have provided, and nobody has objected during examination, so we take it for granted. Okay, as you know, it's always the burden of evidence thing that if you have something stated and nobody's contested it, then it's taken to be granted. So you have to be very explicit and detailed with respect to this, and you still should get forward and with trying to capture inventions. I'm confronted with a phenomenon, let's call it a phenomenon. The smarter the people they are, the more they believe it is a standard measure they have taken. Although me
Yeah.
being an experienced patent lawyer, I'm usually saying, hey, this is cool. This is something we haven't found in the prior art.
Right.
For you, it is just a tool you have
But it's
applied.
also because they're so involved in it that, to them, they've been working on it for 6 months, a year, whatever. To them, they're so used to it that it just seems like, well, of course. I
Yeah,
think,
absolutely.
yeah.
And what else kicks in here is very often academia is also involved here, at least in the startup scene. It's very often coming from academia, and they are still thinking in terms of this early publication, collecting the impact points thing. And then we have to tell them, hey, first a patent application, please. But even if there is a paper already published, we will find technical specifications that haven't addressed in this paper. And then, of course, we have a limited story to tell, but then we will try to tell this more limited story, of course, with then, I don't know, perhaps the scope not being as broad as before publication, but also this can be handled. This is what I'm trying to say here. Usually, you should get in touch with Michael. You should ask your patent lawyer, even if
But
something has happened.
actually, two things come to mind. One is in the United States, we get a grace period.
Yeah.
In
We,
Europe, you don't. Is it an absolute novelty region?
Yeah, we have the absolute novelty requirement. There are ongoing discussions about this topic, whether Europe shouldn't adapt to the US system. I would agree. We have a kind of a limited grace period in Germany and I think in Austria and Denmark, as far as I know, on the basis of the utility models, these petty patents, these small patents.
Right.
We have a half-year grace period. Problem is with utility models, they only protect devices and systems, no methods or procedures. And usually you try to capture software by way of method claims predominantly, and these are then not possible. But also there we usually find a solution.
So, I mean, that's what I try to tell my clients, even like in the United States, file before you do anything.
Yeah.
Because of this, or at least file a provisional application. My second question that comes to mind is, I mean, here it's very difficult if you're just gathering information, doing some magical calculation and outputting something. Uh, I assume it's similar there, and you need to show some kind of, like you mentioned, more technicality where you're either saving memory or you're saving power
Yeah.
or you're doing something, not just doing it on a computer, but actually uh, doing it in a more efficient way or something with a computer.
Yeah, absolutely. And Michael, it's easy to do, by the way. Nowadays, also with Gen AI, which helps a lot, ask patent lawyers to understand the whole value creation in this business, and then also trying to start thinking, hey, can't we expand what we call the share factor, meaning the inventor being a very decent person, very smart person, is usually thinking of the core of the invention as a field of application. But very often it turns out, no, there is also downstream, for example, there are other fields of application. And
Yeah.
this should be also kind of mentioned in the original patent application. This is a contribution we patent lawyers can provide because usually, which is okay, of course,
Uh,
the inventors have a more narrow look, as they are so decent, more narrow look onto their subject matter. And they, of course, being scientists, they know this should be proven evidence. Here we are more liberal. Also in Europe, you don't have to show really that this is working, is already in practice. It should be plausible, it should be reproducibly explained, but that's it basically. And there's a lot of room we can then fill with further arguments and details. So it's a good cooperation between the inventors, the US colleagues, and us to fill then or slightly change also the specification according to our needs.
okay, well, that's all the time we have for now. Any parting wisdom, pearls of wisdom?
Haha, yeah, yeah, that's a good one. I think, Michael, what is really nowadays necessary, I'm a bit criticizing also our patent business. I think it is turning more now to again have the requirement of really a higher quality level with respect to inventive step. And I think this needs better preparation of the application. So this is my biggest finding over 30 years of experience. We better do a good job. Quick and dirty doesn't pay off at all. Particularly than having that the in mind that the subsequent costs are huge. Okay,
Yeah, to
if you
deal with
want
it
to
in
be
prosecution and try to deal with the rejections and with the validity
absolutely.
and enforceability.
Yeah, this is 10 times more than the initial costs on
Right.
drafting, and you better spend more time, a bit more money on the drafting. It really pays off.
Yeah, I think there's a saying in the US, penny wise, pound foolish.
Yeah, exactly.
Right. All right. Well, thank you so
Good.
much, Axel. I've
Yeah,
learned
it's a
a
big
lot.
pleasure.
Hopefully, the audience has learned a lot. Till next time, audience, thank you for tuning in to Unraveling Intellectual Property with Michael Stein.
Mhm.